Hello and welcome. My name is Todd Hutchison, and in this session I want to talk about the elements of an offence. The phrase elements of an offence represents the key factors that must exist for a crime to be recognised. These two key elements or factors are, firstly, it must be an act that represents prohibited conduct, which effectively means doing something or attempting to do something or conspiring to do something that is illegal. And secondly, the mental element of a guilty mind or an intention to commit a crime. This means the prosecution must, in order to prove that a person has committed an offence, show that both of these elements were present. Now take the example of assault and battery. And by the way, assault does not mean that you physically hit the person. It is a situation where there is a threat of violence and where a person is put into a state of fear. Whereas the term battery represents the physical violence. Now, if a person intentionally strikes another person without their consent, an offence can be committed. The prohibited conduct is the actual striking, and the mental element or the concept of a guilty mind was that there was an intention to harm, strike or hurt them. By the way, this assumes that there was no lawful excuse, such as a person striking back in self-defence or where they accidentally striked another person. In this case, no criminal offence occurs because the mental element or that guilty mind was absent. Sometimes a person may commit an offence by acting recklessly without a specific intent. However, their actions had disregard or were showing that there was no care to consequences that may be held that they were meeting those elements. We've been talking so far about absolute liability. So for completeness, I will also note the intent does not need to exist in all cases, such as where an offence falls into the unusual category of what is known as a strict liability offence. This is basically crimes against public policy rather than any inherent moral wrongdoing. In these cases, the prosecutor only needs to prove a crime was committed independent of the intent. An example is when you're speeding, as the mere fact that a person was driving at a prohibited speed. With strict liability, when defending allegations, providing evidence that the person was misled or may have an honest mistake is a good strategy. This is a special case, however, and it kind of distracts from our conversation about the two key elements. So the last aspect I want to cover is auxiliary criminal responsibility. See, a principal offender is a person who performs a prohibited act. However, others can be prosecuted where they aid the principal offender on the basis of some joint enterprise, as it's called, such as where they promote, aid or abet, or they conspire to commit an offence. Those who do encourage or give their aid for the offence are also known as accessories to the crime. A person who attempts to complete a crime can also still be prosecuted for their attempt. In this case, the evidence would need to show that they attempted but failed to complete the offence. And lastly, you can prosecute a person who plans a crime where they're found guilty of conspiracy to commit a crime, even when there's no attempt to commit that crime. So in summary, the questions to confirm: did they have an intent or acted with no regard to consequences, and did they attempt, conspire towards or commit a crime?